name is Crady DeGolian, and let me welcome you all to the second in what is an ongoing webinar series the Council of State Governments, in conjunction with our National Center for Interstate Compacts, is hosting to begin to talk sort of broadly through compacts, how they function, a little bit about their history, and those sorts of things. Today's webinar is entitled Interstate Compacts and the Federal Government, and for the second time in about 6 weeks, we are lucky enough to be joined by Rick Masters, who, amongst other things, serves as legal counsel to the National Center, as well as several different interstate compact commissions affiliated with the Council of State Governments. Just a couple housekeeping items before we get started here with the formal webinar. Much like last time and much like all of CRSG webinars, you will be in listen mode only, and we'll be able to submit questions using the text box that will come directly to our staff. If you have questions, you can submit them at any time. We will get them, and I will simply read them off to Rick as they come through. The other thing I will say is the webinar will be posted online through CSG's Knowledge Center and our website probably by the end of this week, or more likely perhaps as early as sometime early next week. As a registrant for the webinar, you will receive notification when that does get posted, but certainly if you have any questions, you're welcome to reach back out to me. My contact information will be provided at the end of the webinar, as well as Rick. We're going to try something a little bit different today. I wanted to try to make this a little more interactive and a little more engaging, and so Rick probably won't take as long with the presentation as he did during the last webinar, with the goal of leaving a little bit more time for audience questions and those sorts of things. So I encourage you, if you do have questions, to submit them as soon as you think about them through the text dialogue that we spoke about a couple minutes ago. With that, let me introduce Rick. I'll give you the highlights of his bio, and then I'll turn the floor over to Rick for a little more formal presentation about compacts and the role the federal government plays in them. Rick Masters is the Special Counsel for Interstate Compacts and legal consultant to CSG's National Center for Interstate Compacts. As I said, he also provides legal advice and counsel to 3 National Interstate Compact Commissions, which are affiliated with CSG. He received his BA from Asbury College here in Central Kentucky and his JD from the Brandeis School of Law at the University of Louisville. In a former lifetime, Rick was the Assistant Attorney General here in the Commonwealth of Kentucky, and also served as General Counsel for CSG at our national headquarters here in Lexington. He has written extensively on the subject of compacts and is the principal draftsman of 3 different interstate compacts: the Interstate Compact for Adult Offender Supervision, which has been enacted by all 50 states, the Interstate Compact for Juveniles, which as of yesterday has also been enacted by all 50 states with the signature of Governor Deal in Georgia, and the Interstate Compact on Educational Opportunities for Military Children, which has now been enacted by 47 states. Rick has also consulted with CSG on a number of other compact projects, and I suspect, as he will talk about, is involved right now with several of our other ongoing work, including a number of compacts in the world of medical licensing. Rick has also written what is the primary tome on interstate compacts, entitled Interstate Compacts, the Evolving Use and Changing Role of Interstate Compacts, a Practitioner's Guide. Rick has been a tremendous friend and resource to the Council of State Governments and to our National Center. So with that, let me thank Rick, and I'll turn the floor over to him.
Thanks, Crady, and I'm happy to be here at the mothership, so to speak, at CSG headquarters in Lexington on an increasingly sunny day. It started out rainy, but we're glad the weather's improving, and we hope that all of you are ready for a stimulating discussion on this area called interstate compacts, and particularly with emphasis upon the federal role and federal involvement in interstate compacts. Let's just recap some of the reasons that make compacts a favorable alternative for state policymakers to look at the means of solving problems that extend beyond borders of one state, and see for you five of those reasons. So the only reasons that I have summarized the primary reasons why interstate compacts are attractive, and among those reasons, the reasonable or national competence The magic or beauty of the compact is that uniformity to be achieved without needing authority to the central federal government. As maybe you are already aware, sometimes the association is the only way to achieve uniformity among our 50 states in subdivision is through some sort of in Congress to bring the field and including unity. That is not the only means of dealing with these problems. And certainly compacts, if they mean anything, they stand for the proposition that states can collectively regulate problems without ceding responsibility to the federal government and allowing states to solve the problems at the level of states. It also continued federal involvement that is appropriate. And we will talk today particularly about compacts in which the federal partnerships have occurred and been facilitated and other avenues for federal participation. Of the Constitution might lead you to believe that all compacts require consent of Congress in order to be effective, because it says literally no state shall, without the consent of Congress, enter into any compact with another state, which grammarians might tell you means all compacts require consent. Well, let me hasten to disabuse you of that somewhat common sense notion. The Supreme Court has held in a number of cases, including the one you see on the screen there involving U.S. Steel versus the MultiState Tax Commission, that only some compacts require the consent of Congress in order to be effective. So in other words, for purposes of the compact clause, as I frequently say when we're discussing this issue, any does not mean all, according to the U.S. Supreme Court when it comes to congressional consent. The only compacts that are required to have consent are those which infringe upon or in some way impede the enumerated powers that are delegated to our federal government by the Constitution. Other than that, states are free to enter into compacts and agreements with one another without the need for congressional consent. Let's go to the next slide. Let's assume that congressional consent is necessary. And there are ways in which that could occur. As this slide mentions, the federal activity and action encouraging states to consider compacts may or may not include consent. If there is formal requirement for consent, that can be granted in several different ways that we'll talk about in a minute. A couple of examples of compacts that did require congressional consent are the Interstate Compact for Adult Offender Supervision, which we abbreviate by its acronym ICAOS, and the Indian Gaming Compacts. The reasons why congressional consent was needed in these two areas involves, first of all, with adult offenders under the Interstate Compact for Adult Offender Supervision, transferring offenders from one state to another when they are on parole or probation is a substitute or an alternative for extradition. An extradition of fugitives from justice is regulated by virtue of the extradition clause of the federal Constitution. So because this compact involved an activity that might arguably infringe upon an enumerated federal power, i.e. extradition, congressional consent was required and was received for ICAOS. Similarly with the Indian Gaming Acts, by which casinos and other places where gambling activities are permitted on behalf of Indian tribes throughout our country, or Native American tribes, consent of Congress was required for states to enter into relationships with these tribal entities because this involves interstate activities that could involve interstate commerce. There are situations, however, where congressional consent is not required or may not be required, but which Congress may have some legitimate authority and interest in regulating. And states are sometimes encouraged to act by the, I hate to use the term threat, but by the prospect or threat of federal legislation. And some examples of that happening include several of the compacts that CSG is currently involved in formulating regarding the health professions, including the medical profession. There was also a compact involving surplus lines insurance, which is mentioned in this slide, that was similarly encouraged by congressional action. Next slide. If consent is required under the Constitution and the Compact Clause, there are three ways in which this could occur. And on this slide, the term explicit consent is used as one way in which Congress grants its consent. And typically that would involve actually permitting Congress to review and render a determination as to its consent or not subsequent to the drafting of the compact and adoption by the states. Obviously, that could create some problematic issues if the states were to go ahead and enter into the compact requiring consent and ask for congressional approval after the fact. So in many cases, when consent is required, it is granted prospectively or in advance, and it's termed here as preemptive consent, where advance consent is given for the compact by Congress prior to its actual enactment by the states. An example here would be the transmission line siting compact. Another example that's not on this slide involves the Interstate Compact for Adult Offender Supervision, in which congressional consent was required in advance and was given in advance. Finally, there is implied consent, where states enter into a compact which the Constitution might arguably require consent, and Congress simply acquiesces in the activity of the states having enacted the compact. I must add that this procedure is not without some risk, because the states are taking it on faith and making some assumptions, perhaps, that congressional consent is either not required or that Congress will, in fact, approve by doing nothing. And that's not always the case. Next slide. So you may be asking at this point, well, what difference does it make? I mean, if consent is required and is given, why is that important and what effect does that have? Good question, and the answer is equally important. By granting congressional consent under the Compact Clause of the Constitution, according to the Supreme Court, the compact provisions and the rules adopted by a compact require the status of federal law. In other words, the compact receiving congressional consent is transformed into the equivalent of federal law and must be given that way by courts interpreting the compact and by those regulated by the compact and those charged with responsibilities in the state for enforcing the compact. That means that as federal law, under the supremacy clause of the federal Constitution, compact with congressional consent and the duly authorized rules will take precedence over convening state laws or regulations. The other 2 points to keep in mind based on the slide we have here is that if Congress denied consent to the compact requiring it, then the provisions of the compact would be void. And obviously, you want to be sure if you're going forward, activity of congressional consent side, to form to discuss that to part of the Constitution. As the vernacular phrase is used, it is what it is. If federal consent is required, then so be it. But that's not to say that there aren't occasions when federal participation in a compact and federal and communication and regular interaction with the federal government is not a desired result, even if it's a compact that does not require congressional consent, and certainly with compacts which do. And there are examples in which the federal government has continued to have an active role in being a participant in compact activities. And we've included several examples here, one of which I mentioned already. The Adult Offender Supervision Compact recognizes a federal role for an ex officio member of that compact commission being on the compact commission to engage in communication on behalf of the federal government. A similar role exists in the Interstate Commission for Juveniles, in which obviously the federal government is involved on a frequent basis due to the interest in and emphasis upon juvenile justice at the federal level. Finally, the Interstate Compact on Educational Opportunity for Military Children is another example where federal participation is desirable and has been a necessary part of the activities surrounding that compact since its beginning. The Department of Defense was very supportive from day one with the provisions of that compact and its emphasis upon problems experienced by military families who are suffering from problems resulting from deployments and resulting transfers from one state public school district to another. There have been other compacts that are ongoing in which federal participation, either as a direct stakeholder or in some cases a funder, has been involved. And one of those examples that's on this slide involves the Emergency Medical Services Compact that is now being developed in work that Grady and I and others at CSG here are doing. Finally, there are examples, as I mentioned, of ex officio participation on compact commissions, and one example is the Department of Defense schools that are maintained on military bases around the world is an ex officio member of the Interstate Commission on Educational Opportunity for Military Children. And in fact, in that compact, the DODEA, which is the entity managing DOD schools throughout the world, has entered into a memorandum of understanding with that commission in which the Department of Defense has agreed to abide by the provisions of that compact involving children coming in from foreign soil who were attending DOD schools and returning to the United States to a state school district subject to the Interstate Compact on Educational Opportunity for Military Children. That also applies to students leaving the United States bound for duty overseas who will be attending DODEA schools in a foreign country. This is just a general starting point, we hope, for some discussion today on an important role that the federal government plays in compacts, whether it's through consent or through participation on other levels. We have plenty of time left, in fact, almost 40 minutes left for questions and dialogue if there are those of you who wish to engage in a conversation, and we'd like to do that today. If we run out of time or we run out of questions and you have the need to inquire further, please use our contact information on the screen, either through email or through telephone. At this point, Grady, I'll turn the baton back to you.
Thank you, Rick. Let me again extend a sincere thanks to Rick for not only joining us, but for making the drive over from Louisville to Lexington today. As Rick said, and I said in some of my opening comments, one of our goals here today was to try a little bit something different and to engage more in some audience questions and those sorts of things. This is a very specific niche in the world of interstate compacts, but we thought it was one that was appropriate and important to discuss, sort of given the perception of interstate compacts as a way to avoid federal preemption. And I think that probably leads to the first question that I have. Rick, oftentimes compacts are viewed as a way for states to work cooperatively while avoiding some kind of federally mandated solution, and yet you seem to paint a slightly different picture. In your slides, you suggest that compacts provide a way for states to work cooperatively together while including both federal agencies and Congress in the discussion. Why do you think that disconnect exists between the perception that compacts are simply a way for states to avoid federal preemption and the picture that you actually paint about states and the feds working together through the compact mechanism?
Well, sometimes Grady, through a lack of communication or perhaps past experience, legislatively and otherwise, tension has developed because there are examples that I won't give specifics at this point, but there are situations where the central federal government and the states have disagreed on how particular problems should be managed. And frankly, and perhaps to violate what I just said, health care is one of those issues where, for a number of reasons, the federal government has become involved in the management of health care in a way that some would say is unprecedented under the Affordable Care Act and other such solutions. And there are plenty of vigorous discussions going on, robust discussions and debates about the wisdom or lack thereof of involvement of the federal government in those sorts of activities. In fact, I think many times the federal agencies charged with regulations of all kinds involving conduct in which some type of regulatory or law enforcement is involved would prefer for states to occupy the realm that is appropriate for states to occupy under our federal constitution. In many cases, some I mentioned here today, the federal government has actually encouraged states to exercise their prerogatives in the Congress in those appropriate ways. For instance, with the Department of Defense and the Military Job Aid Compact. From day one, the Department of Defense, even though it has military members who have their direct responsibility, and aware that military members are experiencing troubles at home, transitions to family transformation, that they move about the country under orders of the DOD. That problem needs to be dealt with. And DOD not once, as far as I'm concerned, on there, that's something that the federal government should undertake to solve instead of states. And so the Interstate Compact, or in the case of the outgrowth, DOD as a federal agency, which deferred to the states and believed and continues to believe that states should solve these types of problems. Rarely, traditional exercise control.
A follow-up question that I have. You talked earlier about how consistent your compacts with the status of federal law. You know, it might be able to go into a little bit more detail about some of the advantages and disadvantages to see that beyond those nothing to the federal law.
I think in terms of enforcement, and compact has congressional consent would be preferable because it takes precedence over constraining state provisions that might clearly to enforce or carry out the responsibility of the compact. On the other hand, there's sort of a gray area, frankly, in which there are transactions which might or might not require consent, and the law is not completely clear on whether compact consent can be granted if, in fact, the activity sought to be regulated by the states does not actually interfere with or intrude upon a enumerated federal power. So it's one thing to seek consent where it's clearly required because the Constitution says so, and another where you may be seeking some advantage of giving the compact greater weight, if you will, for enforcement purposes, but where it's not clear that congressional consent is required, whether it can be given in that circumstance. And frankly, the courts still haven't finally opined on that particular nuance. So I think we have a situation where our country is one in which our Constitution recognizes dual sovereignty. We have the federal government that has certain limited roles and enumerated powers that are given to it under the federal Constitution, but our Constitution also recognizes that we are a collection of sovereigns, 50 to be exact, which have their own constitutions and which have their own sovereignty over a wide variety of matters that states have in the past and will continue to regulate at the state level. And so when we go forward, I think we ought to analyze each problem that we're considering a compact as a possible solution for to determine traditionally and historically what has been the role of the states or what has been the role of the federal government. Many times, simply using that analysis, the issues shake out in a way that it becomes clear whether consent is required and should be sought.
Yeah, let me ask you a follow-up question, Rick. One of the issues that's come up in all of our ongoing medical compact projects is that question of consent. And your point about something being left traditionally to the domain of the states, I think has been our traditional answer to that question. Could you speak a little bit more specifically about why in those instances you don't think consent is going to be necessary?
Well, here again, states have traditionally regulated professional practice in a wide variety of professions, whether it be law, medicine, insurance, and a host of others. The primary purpose of the regulation of professionals, such as doctors, lawyers, and engineers, and any number of professions requiring licensure, is to protect public safety. That's been a role that the states have taken very seriously, and I think for the most part, over the last 100 years or so, particularly since we have been involved in professional regulation through licensure at various professions, that has been the critical role of the states. I believe that in the case of health professionals, that because of the traditional regulatory role and the 10th Amendment concerns that are involved with the regulation by states of state activities, that this is an area where states can appropriately exercise their sovereignty collectively, and congressional consent is not in fact required. Let me be frank, there are some disagreements about that, and there are some in Congress who think that because interstate commerce is affected by professional practice of all types, including health professions, doctors, nurses, etc., across state lines, that there may be a justification for federal regulation. And I think the concern that the federal government may have a basis for making such involvement a matter of requirement or for becoming involved in a process by which federal regulation of professions could become a reality, that is driving states in a direction which I think they should probably be headed in anyway, which is to consider how can we promote license portability, access to care, opportunities for professionals to practice across state lines, but still protect public safety.
Okay. I know we've got a couple audience questions that have come in, and we'll get to those in just one second. Let me ask a follow-up question, Rick, and it's a question that I get all the time from our membership at CSG, and I don't know if I've ever answered very well, so I'd like your take on this. What is the most significant challenge to receiving consent on a particular compact? Are there avenues that states or a particular compact should follow when trying to seek consent? Like I said, it's a question I get regularly, and I'd be interested in your take on that.
Well, broadly speaking, it's always better if the states have a wide variety of options. And so advanced consent of a very general nature is something that I think the states would prefer. I'll give you an example of what I'm talking about. The Interstate Compact for adult offender supervision, for example, was consented to in advance by the Crime Control Act, which was initially adopted by Congress back in the 1930s. That consent legislation was very general, and all it said was essentially that states may enter into compacts or agreements concerning public safety and the control of crime. That's about all it said. And so filling in the details was largely left up to the states. And I think states would probably prefer that only a general and broad consent clause of a particular federal act be used as the method for Congress to give its consent. On the other hand, there have been congressional consent statutes which were much more detailed and which had other requirements that Congress is entitled to impose on compacts that would infringe upon or arguably conflict with enumerated sovereignty of the U.S. government under the Constitution. Those compacts would be typified perhaps by the low-level radioactive waste compacts, which had to comply with some other necessary federal requirements which furthered federal energy policy with regard to the use of nuclear energy.
Okay, a couple audience questions have come in. The first one, in regards to professional licensure compacts, such as the nurse licensure compact that you alluded to, or medical licensing efforts ongoing, in light of congressional efforts to address licensure barriers to the television, is the role for Congress to play in advocating for even mandating states to look at that?
The answer is to qualify that. I think both the states and the federal have to be careful that they don't go beyond their respective spheres of regulation. But yes, I think that congressional encouragement of enactment of licensure statutes which would provide for portability for licenses by the state is something that is and will in the future continue to motivate states to do so. And I'll have to, again, I'll have to be frank, that those statutes, including one that I'm familiar with, where federal control would actually be imposed by creating a federal license, which would be regulated federally, and which presumably would still require the states to engage in professional discipline and other matters through a bifurcation of licensure from state functions to federal functions. There are very many states that do that.
Next question directly in asking every now and then compact cases end up working their way through and up to federal courts. Could you talk about how frequently that happens? Anything that might be ongoing, especially if it's not for the question that you're still aware of the MultiState Compact, and how that might play into that question of the Supreme Court of Interstate Compact.
Typically, because compacts involve agreements and contracts between states, where there is a controversy between one state and another state, the federal courts would have jurisdiction over that controversy. That's not to say that there aren't compacts which, by their terms, allow certain matters to be decided in state court, but where it's a question of enforcement or compliance with a compact agreement that has been entered into by multiple states. Ultimately, the Supreme Court of the United States would have the last word because it's state versus state. However, because much of the jurisprudence that has been decided by the courts indicates that in order to bring an original action between one state and another to the federal court, it's a very cumbersome and somewhat protracted process. And in order to avoid that, what many more recent compacts have done, including several that we've mentioned today, the Adult Compact, the Juvenile Compact, and the Military Education Compact, is to provide federal jurisdiction of the compacts in federal court for resolution of disputes so that there's no question that those matters have to be taken into federal court for trial and determination. Now, in terms of how that actually works out in practice, as you made reference to in the early part of the introduction, it's been my privilege to represent a number of compact agencies. And there are ongoing administrative activities that the commissions that manage these compacts engage in, including appropriate promulgation and enforcement of rules, as well as the assessment and collection of dues appropriations from the member states. There are cases where rules are not followed, in which violations occur, cases where a member state may have neglected or failed to pay a dues assessment that's been levied. And so those cases are somewhat garden variety litigation that is enforced on a, if not regular basis, at least an occasional basis. Where we get into more substantive and constitutionally based issues concerning compacts, such as some issues that have been raised in the litigation that you mentioned concerning the multi-state tax compact, those are more rare, but again, not unprecedented. And those cases usually find their way through either the Supreme Courts of states that have to wrestle with those particular compact provisions and may ultimately wind up in the Supreme Court of the United States, and frequently draw lots of interest from stakeholder groups and others that are regulated by that particular compact entity.
Rick, any sense how those various cases that are working through state Supreme Courts might play out with the multi-state tax compact? I think there is a case in Michigan, a case in California, and perhaps one pending in Oregon, all pertaining to the compact. Any sense how those might play out, or is that a little too early to assume?
Well, I think the issues in those cases are important, one of which is whether or not a contractual agreement through an interstate compact allows for variation to the point of a state enacting a provision that would actually be contrary to or contradict the terms of the compact. And traditional compact law and much of compact jurisprudence from the U.S. Supreme Court, as well as lower federal courts and some state courts, have maintained consistency with respect to the inherent proposition that a compact, first and foremost, is a contract, and that as such, not only are those instruments protected by the compact clause of the Constitution, but by the contract clause of the Constitution, which provides that a state can't impair a contract by enacting a conflicting law. So I think the court, in those cases you mentioned, is going to be looking at those issues to determine to what extent they apply in these cases.
Okay, Rick, one more audience question. We've still got about 10 minutes or so before we wrap up, so if you do have any last-minute questions, there's still another opportunity to get those in. Like I said, submit those as you have been via the text box, and they will come directly to our staff. This question from the audience: are the provisions in the Constitution that would prevent, are there provisions in the Constitution that would prevent Congress from mandating a compact? In other words, can you expand on your point about sphere of regulation?
Well, I'm not sure I entirely understand all the nuances that may be in that question, but I will say this. Because the compact clause of the Constitution does give Congress the power to determine whether consent is required, it does act as a catalyst in many cases for the states to act in a way that might stave off or prevent Congress from becoming involved in an area that has already been satisfactorily resolved by the states. And I think that may be what we're seeing in part with respect to some of the ongoing efforts occurring currently here in multiple health professions, including the doctors, advanced practice nurses, emergency medical technicians, physical therapists, and others, where there is a, I hate to use the term fear, but I think that might be appropriate, fear by the states that perhaps the federal government will intrude upon, or in their view, become involved in an area that states should take care of. But if there is a need for uniform and collective regulation by the states, which will provide multi-state licensure and licensure portability to deal with some of these health issues, such as access to care, the ability to more effectively practice telemedicine or electronic examination, diagnosis, and treatment across state lines via the internet and other electronic devices, then I think the best way to avoid the need for congressional action would be for the states to take action themselves for solutions, even if there is a legal time to do that.
That's really excellent question. I think it's really handy to get back to what we're trying to accomplish here today. So we'll go through all the information a little bit more time for Q&A. We've got about 45 minutes. If you feel free to reach out and respond, or they'll be on. And if I can't reach out to you, the topic. With that, I would like to once again Rick for not only taking the time to join us, but for sharing his tremendous wealth of knowledge. As I said earlier, the slides and the webinar will be posted tomorrow. Probably early next week. You will get an email notification. And so I want to thank everyone for taking about 45 minutes of the day to talk to this topic with us. This is we all national centers very key work.